Now I move on to introducing the most respected chief guest present amidst us today, Professor Dr. S.G. Sreejith. Before talking about his life and his achievements, I have two interesting things to tell about our chief guest. While I googled his details for the introduction, I was fascinated by two things. Firstly, the Jindal Global Law School. All of us know that it is one of the top institutions of the country, and there are several students who aspire to study in the university. And through my friends during my days at law college, I've heard a lot about the university. So I think the very name is a very fascinating feature for our chief guest. Apart from that, while I was going through the achievements of our chief guest, one thing that struck me was his works on international space law. Only after going through the articles which our chief guest has published, I happily recollected that even I had made a reference to one of the articles during my moot court days. While I took part in the Luthra and Luthra International Space Law moot, I had referred to our chief guest's article on international space law, a saga of mankind's lost aspirations, published in the Alco Quarterly in the year 2006. So with immense pleasure and happiness, I invite our chief guest, Professor Dr. S.G. Sreejith, to the Decennial lecture series. To give a formal touch to it, I would just like to add a few words about the achievements of our chief guest. Dr. Sreejith S.G. is an associate professor and the associate dean of academic affairs, and also the executive director for Center of International Legal Studies at Jindal Global Law School at Jindal Global University. He had his higher education from the University of Lapland, Jawaharlal Nehru University, and the University of Kerala. He has previously worked for Arctic Center, National University of Advanced Legal Studies, and the University of Petroleum and Energy Studies. Our chief guest is also the author of the book Transcending Jurisprudence, a critique on the architectonics of international law, and he has also published several articles in top journals such as the San Diego International Law Journal, California Western International Law Journal, Indian Journal of International Law, to name a few. He also sits on the editorial board of Indian Journal of International Law, and his areas of specialization include public international law, heterodox approaches to international legal thought, and perennial philosophy. All of this really sounds very amusing and also new to most of us, I believe. So, with much eagerness, I now request the most respected chief guest, Professor Dr. S.G. Sreejith, to take over the podium. Thank you.
Thank you, Honorable Justice and respected members of the bar. It's truly an honor to be here, for which I sincerely thank my dear friend and internationally trained, internationally practiced lawyer, advocate Puhar Gandhi. Had it not been for him, I would not have been here. So a sincere thanks to everybody. So without much ado, let me start the presentation. But one caveat before I start. I'm going to speak from a left, a legal left. I must again caution you, it's not a political left. I'm not going to take any ideological perspective to law, but I'm simply going to talk from a legal left. By legal left, I simply mean a space of radicalism, a space of dissent, and a space of renewalism, a space of newer imaginations. It's what all I'm going to present before you, they are simply food for thought, which we have experimented in the classrooms. Now we need to see the possibility of a transition of this from classrooms to the courtrooms. So I'll structure my presentation in this way. First of all, let me explain the concept which is classroom to the courtroom. It's not just casually that I've written the term critique and move from classroom to the courtroom. I've conceptualized the transition from classroom to the courtroom. After that, I'll use a little bit of the celebrated writings of Professor Duncan Kennedy of Harvard Law School and problematize the legal education. And drawing on Duncan Kennedy, I'll argue that law school needs to strike down many of its hierarchies, many of its internalizations, many of its beliefs and credos, and law schools need to turn critique. To my understanding, law school has successfully experimented with critique. I'll explain very soon what do I mean by critique. But then once the nature of the law students change from being the conventional law students to critically minded, critically cultured students, what awaits them in the courtroom, when the courtrooms offer them spaces of criticism, spaces of critical imagination, spaces of dissent or not, that's what I'll be exploring. And finally, I'll just give some random thoughts on what are the critical spaces available in it. I'm not very confident speaking about that, the critical spaces available in a courtroom, which I'll leave for the learned lawyers to brood on. So first of all, let me conceptualize the transition from classroom to the courtroom. Now we know that we often say this is a natural transition, but we know that this is not a natural transition because somebody who goes through the transition from the classroom to the courtroom feels a discontinuity, a disjunct, that whatever I have learned in my classroom, that has been discontinued. So the continuity is absent from the classroom to the courtroom. Literally every one of us has gone through this kind of a transition. Some of us experienced a strangeness in the court when we were immediately transposed from the classroom to the courtroom. Some of us feel alienated from the classroom when we found ourselves in the courtroom. Some of us experienced a nihilism, utter nihilism and pessimism. Most of us accepted the reality that courtrooms are different. Now comes the most important question. So what were we learning for 3 to 5 to 7 years in the law school? Was it a waste? That now I'm feeling a discontinuity from what I have learned, what I've learned in the classroom. Now, the most of us who have adapted to the changed conditions of the courtroom, we are willing to sacrifice the 3 to 5 to 7 years in the law school, and we have now settled in with the transition that court is a different place. We also accept a sentiment that law schools don't teach legal practice. This leads to a sense of reformism also, which most of the lawyers think that now we need to go back to the we need to go back to the classrooms and add a large dose of practice in the legal curriculum. So the transition, what I'm talking about is a discontinuity followed by different sensibilities like nihilism. Sometimes we feel ambivalence. Sometimes we settle down with the ebb and flow of the time and we say that we have transformed, we have adopted the court culture. But then it has two residue. One is the reformism that we need to transform the classrooms, and second, law schools don't teach legal practice. So I'm asking the question, is it in fact the case? My answer is that no. It's an emphatic no, that this is not in fact the case. If law schools have to become practical training institutes, then law schools will have to adopt a culture in a chamber or in a courtroom, which I don't think the law professors are competent to teach. So what does the law school teach? My presentation is going to be that law school, there is an overestimation about the role of the law schools, that you come to the law schools to learn legal practice. This is the overestimation about the law schools. We all come to the law school, or the customized form of law school teaching is that it's a vocational training institute where we learn the technique and the phronesis. The technique is the skill. The phronesis is the rationality to apply the skill. I would say that the skill we talk about is not the lawyering skill. The skill we talk about is the skill to critique and the rationality to apply that critique in the daily life, including the courtroom. So there is a misconception somewhere. I don't know who created the misconception. There is a misconception that law school teaches legal practice. None of the law professors are competent to teach the legal practice because professors are armchair theoreticians who live in their ivory towers. Now, in order to better problematize it, rather than me going for a loose critique of saying that there is a misperception about the law school, I've used the foundational work done by Professor Duncan Kennedy in Harvard Law School, who problematized legal education. Some of you might be interested to hear about Kennedy's own critique of the law school and how he says that critique can redeem the maladies of a law school and provide a smooth transition from law school to the courtroom. I'm just drawing on the Duncan Kennedy. One more caveat, Duncan Kennedy is mainly talking about an American law school, not exactly an Indian law school, but of course we can find a lot of parallels in Indian law schools as well. I can vouch it as a law professor that such situations prevail in Indian law schools as well. Now, before that, some general perceptions about the law school, that law schools are meant to teach legal practice. Law schools are too theoretically inclined, that there is more ideological indoctrination and less skill training. And finally, the world of practice should dictate the substance of the law school curriculum? Should the BCI be the curriculum setting body for the law school or not? Now, these are some of the general considerations, but then let's go into Duncan Kennedy's problematizing of the curriculum. Now, he starts with the faculty first of all. He says that an ideal law school faculty or a custom law school faculty is a white, middle-aged, heterosexual, elite male. So law which you're going to hear is from the mouth of an elite, white, heterosexual male. And he has patrician characters. He has his nose up. I'm using the word he because a law professor is predominantly a he, according to Kennedy. That the professor teaches his masculine biases. He teaches his heterosexual biases. And he knows his patrician ways. He knows not the proletarian ways of the society. So the law school professor is ideally a male, white, heterosexual, middle-aged elite who has patrician manners. And the law students internalize their professor when they enter the profession, that the ideal way to be a gentleman is like my professor, who's a white, heterosexual, elite male. Second, classrooms. Those who have seen the interesting movie Paper Chase might know what an ideal American classroom is like. Classrooms are dominated by the white, middle-aged, heterosexual male professor. For first-year law students, a Socratic session is a humiliation session. They are humiliated and they gift an answer to the professor in order to be negated later on by the professor to make the student feel that he knows nothing. So there is a sort of grilling sessions in the first year law school whereby the students go through the Socratic sessions. Socratic sessions have been glorified, adopted by many national law schools in India, including in Jindal Global Law School. But the truth about the Socratic sessions are they are professor dominated. And the participation of the students in a Socratic session is a pseudo participation. They participate for the sake of participating. And this creates a new kind of group in the law school, in the classroom. We call them the gunners. Gunners are the people who literally raise their hands no matter whether they know the answer to the question or not. So when professor poses a polemical question to the class, you will see 5-6 gunners in the class. So gunners believe that the best way to be the pet of the professor is to be the gunner. Now, Socratic sessions are orchestrated, whether one understands or not. They are not extempore. Many times the professor makes the student to speak in the way the professor wants. So I would say that the professor here is a male, white, heterosexual, middle-aged elite. So most of the time the Socratic sessions happen through the elitism, through the masculinity, through the heterosexuality, and through the patrician manners of the professor. Now here what happens is, Duncan Kennedy calls that this all leads to the infantilization of the law students. Ultimately the professor is the parent. The professor is the phantom. He has his own draconian ways to which the students need to adapt. So ultimately, this leads to an infantilization. Now, infantilization happens in the first year of the law school. As the first year goes by, there is a life post-infantilization. Slowly, the spiral, it's like a spiral that you start to spiral outward from this initial shock. Slowly, you revolvingly evolve. Revolvingly evolve. We react to the culture. We read, we speak. And slowly things start to make sense in the law school. So ultimately, what we lose in the law school is our sweet ignorance about our own human ways, and we start to think like a lawyer. We lose our subjectivity and we gain the objectivity. Now, one interesting question Duncan Kennedy poses right after this is, due to all this, the infantilization and the post-infantilization, whether law schools incapacitate the students or not. Generally, the answer is yes, but there are opportunities where there are perspectives taking which will help us dispel this imagination. First of all, I would say that there is an overestimation about the role of the teachers. Ask me what is my role as a law professor. I would say that I'm a museum curator. My job is to museumize the knowledge. Now, what museumization do? I would say that every case, every social event is an occurrence, and occurrences happen in succession. So many times the society has a very poor memory that occurrences do not stay in the mind. So the law professor steps in here, he theorizes, puts the occurrence, each case, each social event in a theoretical mold, and the professor preserves it. So law professor simply does this museumization of the occurrences. So even from a court's perspective, a decision becomes a valid decision or an influential decision not when it is reported by a law reporter, but when the decision is used as an analytical apparatus by a law professor. So the law professor plays simply the role of museumizing the knowledge. Now, we have an overestimation that this museumizer This theoretical museumizer who loves to swim in the edible garbage of theory is going to teach legal practice. So ultimately, there is an overestimation that law professors are simply nothing more than museumizers of knowledge. Second, research-oriented students. Most of the time, they internalize the professor and they would say that I want to be like my professor. I'll be white. If not white, I'll be heterosexual. I'll be straight. I'll be patrician. I'll be elitist. And I know how to dominate my students. So they internalize something from the law school. So law school simply doesn't teach the law. Law school also teaches certain culture. This is exactly the culture I meant, the culture of domination, the culture of hierarchy. Now what the student witnesses in the law school is, even among the professors, there is a hierarchy. I'm not speaking about associate, assistant, full professor or emeritus professor. The hierarchy is that jurisprudence professors are the most elitist and most unapproachable professors in a university because nobody understands what they speak. Second, commercial law professors who can lead you to the most flashy career you're looking for, followed by criminal law professors, and the least important of the professorial lot is the clinical professors. Actually, professors who literally take you down to the real world, who gives you encounter with the social fact and help you interact with this, they are given the least importance in the law school. So Duncan Kennedy argues that such a hierarchy has come in the law school that nobody wants to be the clinical law professor. Everybody wants to be the commercial law professor or the jurisprudence professor. For your information, Duncan Kennedy himself is a white, heterosexual, male, and a jurisprudence professor. Now, research students emulate their professors. What about the others who want to take up careers like litigation and law firm? What can they learn from from the museumizing role of the professor? Well, the professor tells that I'm showing you what exactly is an occurrence. I cannot tell you how the occurrences, I can explain to you how the occurrences happen, but I cannot tell you how to respond to the occurrences. How to respond to the occurrences you will learn in the courtroom. Now, again, I haven't come to the critique yet. This is how Duncan Kennedy says that the law school teaching happens. I've just provided some glimpses of it. So finally, the law school curriculum is also too constrained that law has to be taught in a certain fashion. For instance, jurisprudence. The subject is mainly taught as the epistemological debate of 7 white male dead men. 7 white dead men. I can just tell their names: Hobbes, Bentham, Austin, Hart, Holmes, Kelsen, Dorkin. This is what jurisprudence in the law school is about. Nobody teaches us what the functions of the law in a society is through the perspective of a woman. What it would be from the perspective of a colonized subject like a rickshaw puller living in the semi-urban areas of Delhi. What jurisprudence would be for a transgender. What jurisprudence would be for a sexual minority. Jurisprudence is always taught through the eyes of 7 dead white men.